versus Okuneye Idris Olarewaju. In the same video, the publisher, the very dark man, revealed that Bobrisky made this presentation to an undisclosed friend of his, whom he intended to receive a financial support from. Attached here is a copy of the charge we have marked as Enclosure 1. Given the gravity of the offense, which touches on our core value as a commission, it touches seriously on our core value, and we do not take kindly to the integrity of the commission, one of the best all over the world and in Africa, for our integrity to be touched. Given this value of integrity, courage, professionalism, and collaboration, the executive chairman promptly constituted a team to investigate the claim and equally issued a statement through his various social media accounts to that effect. Whilst investigation is still ongoing, the executive chairman received from this honorable house an invitation directing his appearance and the concerned officers of the commission before this honorable committee for an investigative hearing. Upon close scrutiny and analysis of that video that gave rise to this investigative hearing, the commission observed the following: that the published and widely circulated video contained a private conversation between the ex-convict and a yet-to-be-identified individual who, in an attempt to obtain monetary benefit, alleged the compromises and the compromise of the officers of the commission, the Nigerian Correctional Service, a private legal practitioner, Femi Falana, SAN, and a private and Fals, the bad guy. That in an attempt to induce and convince the yet-to-be-identified individual into parting with his money, the ex-convict alleged that the sum of 15 million naira was demanded by the officers of the commission to drop the count of money laundering counts in count 5 and 6 of the charge sheet, and that he could not transfer the said sum from his account because of the investigation, thereby inferring that the said account was frozen. That at the time he was demanding for this money and claimed his accounts were frozen or under investigation, the commission never, at no time in the course of investigation, placed the account of the ex-convict under personal debit. His account was never frozen throughout the period of investigation. Whereas the ex-convict mentioned the names of his friends who raised various sums of money and credited same to the account of his brother. The names of the officers of the commission that allegedly collected the bribe were not disclosed by the ex-convicts. Also, the mode, the place, date, and time of the delivery of the alleged bribe, or to an account where it was paid, was not disclosed by the ex-convicts. Arising from the above observation, the commission wishes to state categorically as follows. In view of the prevalent nature of the currency, mutilation and abuse of the naira, which has been expressly criminalized by Section 21 of the CBN Act 2027, the commission, in a bid to curb the said offenses and in the discharge of its statutory duty, set up a special task force via a memo by the executive chairman to all his directorates. Now, attached here with is also a copy of the said memo marked as Enclosure 2. As a result of the setting up of this special task force and the vigorous sensitization, investigation, and prosecution, a number of convictions were secured, which has significantly stemmed this dangerous tide of abuse of the naira, to which all Nigerians are witness today. It was in the course of carrying out its mandate that the Special Task Force of the Commission, Lagos Directorate, received intelligence which revealed 4 different videos of gross abuse of the naira notes perpetrated by the ex-convicts, which warranted his investigation and prosecution. That on the 3rd of April 2024, the ex-convict, while undergoing investigation, in his extrajudicial statement, confessed clearly inter alia, Bob Express is not registered as SCUMO, Special Control Unit Against Money Laundering. I'm not aware. Hence the inclusion of count 5 and 6, due to his own confession that Bob Express is not registered. So the prosecutors had to now include all of this and then did a further check on that. Now, in the body of the charge, this was included, wherein the defendant, now ex-convict, was alleged to have failed to submit to SCUMO a declaration of his activity, which is contrary to Section 6.1 of the Money Laundering Prevention and Prohibition Act 2022, and punishable under Section 19 of the same Act, in addition to the substantive offense of tampering with the Naira note as contained in count 4, for count 1 to 4. However, on the 5th of April 2024, notwithstanding the unequivocal confession of the ex-convict, admitting the essential ingredients of in count 5 and 6 of the charge, and having indicated willingness to plead guilty to count 1 and 4 of the charge, the prosecution, in total fidelity and candor to his oath and strict adherence to professional practice of not disclosing documents to their defense, having received a report of the investigation and activities from SCUMO, which showed that Bob Express is not a designated non-financial business and profession, decided to drop counts 5 and 6 of the charge in the interest of justice and fair hearing, without any inducement or prompting of any sort from the defense, and in line with the memorandum of the special, with the mandate of the Special Task Force Against Naira Abuse. We have this also attached here and marked as Annexure 3. That the Honorable House is invited to note that alteration, amendment, addition of charges is known to law, very known to law. Particularly Section 216 of the Administration of Criminal Justice Act 2015. It's also noteworthy to note that it is also noteworthy here to note that the alteration made by the prosecution did not contravene any provision of the extant policies of the Commission, nor a standard operating procedure. That the steps taken by the prosecution in proceeding to drop count 5 and 6, which is akin to amendment of the charges, can take place at any time before judgment is not alien, as the Commission has in numerous instances caused charges to be amended. You can see our attachment as enclosure 4. The Honorable House is urged to use this constitutional power to ensure that corruption and other vices are exposed, investigated, prosecuted, and also ensure that patriotic and dedicated officers are not blackmailed, demonized, and demoralized for faithfully serving and carrying out their lawful duties. That the Commission has been consistent in its advocacy, calling on all public with credible information on any alleged act of corruption involving any of the staff to come forward with evidence. This, the public is urged to do responsibly. Short of the ex-convicts and other accusers openly naming the officers of the Commission to whom they allege gave the bribe of 15 million naira in order to induce and influence the dropping of count 5 and 6 of the charge, bordering on money laundering, it is reasonable to infer that the ex-convict merely made up the story to convince the yet-to-be-identified person he was speaking with in order to obtain financial favor under the pretense by dropping the name of the Commission. We wish to draw the attention of the Honorable House to the fact that the onus of proving this grievous allegation against officers of the Commission rests squarely on the accusers in this case.